Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. Now, on today's podcast, we are going to go deep into the weeds again. So if you listened to a recent podcast that I did, diving deep into trusts, this would be considered part 2. So for those of you who are enjoying the podcast for the entertainment value and just learning a little bit about wills and trusts and estate planning, this one might not be for you. The same as the last one probably wasn't either. These are really deep dives into advanced trust concepts. And today will basically be about what happens after death. So, what happens after death with trusts that were created during life and then created trust after death, and what happened if a trust was created after death through a will or through any form, basically. What does that look like is basically what we'll be talking mostly about today. Again, these are questions that we've been getting a lot. I've been ignoring them because I didn't really want to get into the weeds on these podcasts, but when things start coming up over and over again, I figured, what the heck? But before we get into the content, I did want to remind everybody, do not take what you hear on this show or any other show to constitute legal advice. If you are looking for legal advice particular to a situation that you are having, please reach out to an attorney licensed in the state that you reside in who practices in the area of law that you are looking for advice in. And they will understand the specific questions, the specific fact pattern, and be able to give you legal advice. This show and any other show is for informational, educational, and entertainment purposes only. We are doing this to educate the public so that what happened to my family doesn't happen to yours. But we are teaching general concepts, not specific questions relating to a specific fact pattern. If you would like that and you are in the state of Pennsylvania, please reach out to us at Belomo & Associates at 717-845-5390, or check us out on the web at www.belomoassociates.com. That is B as in boy, ELLOMO. All right, wonderful. All right, so the first question that we're going to address today is basically what happens in trust administration after death? What should my kids expect? So let me just take a step back here. So this question sort of implies or assumes that there was a trust during life that was set up. And now, after death, the question I believe is asking, okay, so now that we have died, what should my kids expect? Generally speaking, the trusts that we are using most of the time at Belomo & Associates are trusts that are called grantor trusts. They are trusts that are created by the grantor. The grantor is still in control, so he or she is still the trustee, and it is in their social security number. They still file their same tax returns on their same 1040s. That is generally the trust that we are using. We do not need to use an irrevocable tax trust or a non-grantor trust with a separate tax ID number paying higher trust tax rates where the grantor has to give up control unless they have more than 13.61 million, and if they are married, another 13.61 million. So we are not talking about those types of trusts for people with more than 27.22 million. We are talking about whether it be revocable grantor trusts or irrevocable grantor trusts. But specifically, the type of trust we are talking about is where the grantor was in control at the time of their death, which means the kids or the estate will be subject to a 4.5% inheritance tax in the state of Pennsylvania. But that also then gets us a step up in basis on the value of the property. So for example, if my dad puts a house in a trust that he paid $20,000 for, that he controls and that he's still in control of at the time of his death, the estate will pay 4.5% tax, but the basis that I receive as the child in that property is, let's call it fair market value on the date of death, $200,000. So if I sell that house for $200,000, what is 200 minus 200? It is 0, right? So we are talking specifically about grantor trusts, whether it be revocable, irrevocable. The big thing here is that it is controlled by the grantor at the time of death and that it is subject to inheritance tax. So essentially what that means then is that as part of the trust administration process, we are essentially carrying out almost the exact same tasks as we would if we were going through probate, right? Probate is the process by which we carry out your legal wishes for assets that are in your name alone at the time of your death. Probate is the legal process that we do in order to carry out those wishes in the will. Trust administration for a trust that the grantor controlled is an awful lot like it, with the exception of, in probate, the executor has to go down to the courthouse, raise his or her right hand, take an oath that they will duly affirm, and abide by provisions of law relating to inheritance tax, blah, 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 and then they sign. So trust administration in this context is exactly the same, except the trustee does not have to go down to the courthouse, does not have to get letters testamentary. That is only in probate. Well, right after death then, the successor trustee will have control of the trust. The successor trustee will be able to pay bills, pay for funeral expenses, and do things out of the trust. But as far as the nitty-gritty about having to give notices to heirs, notices to creditors, advertising, the expenses, or advertising in case there is any creditors out there, paying the inheritance tax, all of that is essentially the same. So when this dawned on me was we were creating trust guides in our office a few years ago for, kind of what has to happen after death, which anyone who works with our firm is provided the guides and they're provided videos and they're given all kinds of education. But it was when we were creating those that I realized they're identical. I mean, with the exception of not having to go down to the courthouse, you are essentially providing or executing the same functions that you would as the trustee as if you were the executor going through that process. Now, the advantage of it being in the trust is that the trustee pretty much gets immediate ability to start acting, and the executor has to go through the court process, which a trustee would not, so that's good as well, and the trustee has the ability to immediately start making decisions and acting on behalf of the trust. But they also avoid the probate costs. The trust do not have to go through the probate cost. And generally speaking, attorneys will charge much less in probate administration. They would charge much less in trust administration than they would in probate administration. So, for example, on average, attorneys are charging about 4 to 5% for probate administration, generally 2% for trust administration. So trust administration provides ability to start making decisions quicker, ability to get access to the money quicker, also reduction of cost from the probate fees to the county and the state, generally reduction of cost for the attorneys, and quicker access and ability to make decisions. At that point then, the successor trustee steps in the shoes of the trust or the person who was the trustee, the person who created it and the person who was the trustee in the style of trust that we are using. They need to make sure that they're paying all of the expenses. If there's funeral bills, if there's any administration costs, there still will be inheritance tax for the trust that we are discussing or the trust that we are typically using. So the money can be used to pay the inheritance tax, to get the returns filed. They have to make sure that they take care of the notices. There will be some advertising costs. They have to do all of that. And then once they do all of that, then they will follow the provisions that are provided for in the trust document about what happens after death. And essentially will set up whatever it is in the document that says that happens after death. So maybe the money goes to the 3 kids equally outright. Then it would be the successor trustee's responsibility to marshal all the assets, pay all the expenses, and then distribute the assets to the 3 individuals outright. In a lot of cases, particularly in our type of planning, we are setting up trusts after death. One of the phrases that I use all the time is you love your spouse and your kids way too much to leave them money outright. And I go into stories about, what happens if I leave everything to my wife and then she gets a pool. And of course, what comes with every pool? A pool boy. And I want her to enjoy it. I want her to have fun. I want the new husband to be able to live in the house and enjoy it. But when she dies, where do I want the house to go? To my daughter, Deanna, right? And then we talk about my daughter, Deanna. If my wife and I are in an accident together, and we both die instantly and everything goes outright. Well, she's 14, so the money would be in a trust until she turns 18. What could possibly go wrong with an 18-year-old, right? Of course, nothing, right? But let's say that the child is older, right? Let's say that the child, maybe my daughter is 30 and maybe she's very responsible. We probably still want the money to be protected, not from her, but for her. So listen to the distinction there. For somebody who's an adult who is responsible, we still want asset protection planning, not to keep it from the individual, but to keep it for the individual. You're not legislating from the grave. You're not controlling from the grave. Absolutely not. You're protecting. It's not about trying to dictate everything. It's about giving the child the ability to be the only one who can get it. Nobody else in the world can touch it, but they get it. Only they get it. They can't lose it to a divorce, a nursing home, or a car accident. That's where the magic comes in. So we'll use my daughter again. If my wife and I were to pass, the money goes into a trust for her benefit. Now, my sister Dina is the trustee of the money for her and will be able to give her money to help raise her, to pay for college, to pay for weddings, to pay for health expenses, to pay for whatever my daughter needs. My sister Dina is the trustee. Again, this is assuming my wife and I both pass away. So my sister will be able to take care of my daughter Deanna after we are gone because she is the trustee. Now my daughter Deanna doesn't get the right to fire my sister, the trustee, until Deanna reaches the age of, and pick an age, right? So for the sake of this podcast, we'll say 45. What that means is up until the time that my daughter is 45, my sister will make sure she's taken care of. We'll give her access to the money. We'll pay for the wedding, for expenses, buy her a car, do whatever she needs. When she turns 45, she is then in full control. Now notice, I did not say that my daughter gets the money outright, did I? Oh, no, 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 no. I said she was in full what? Full control, right? Do you hear the difference? Now, once my daughter's in full control, what can she do with the money, right? Anything, of course. So that's why I want the age to be higher. I don't want it to be 21. I don't want it to be 25. Somebody asked me the other day in a workshop, why did you pick 45? And I was joking and I was laughing, and my response was because my wife wouldn't let me go higher. Now, it's a little tongue-in-cheek. I have a very responsible 14-year-old, a very responsible kid. But that doesn't mean that something won't happen during college, right? My phrase is, you're one good college party away from a stupid decision. So let's make sure that we're not giving full control or ownership at 18 or at 21 if somebody was to put the money into a uniform transfers to minors account. A lot of lawyers use the UTMA accounts as a cheap way to kind of put the assets in trust. But the problem is the money has to go outright at 21. Well, what could possibly go wrong at 21, right? I mean, there's nothing going on at 21 that could make them make a stupid decision. So what we want to make sure is that we're getting well past all of that and that the person is older so that we get through the 20s, we get through the divorce, we get through maybe the addiction phases, or we get through the gambling problems, we get through the stupid life decisions so that we're beyond that, so that now she has the ability to be able to think clearly at 45 when she's in full control, because we can't stop anything once she's in full control. She can take it all out. She can give it to the husband, to the boyfriend. She can do whatever she wants. Now, if my sister believes that she is really in a good place, My sister could remove herself as trustee or allow my daughter to be in full control sooner. But if we give it as an early age, there is nothing that my sister can do if my daughter is going through a crisis, through an addiction, through a divorce, or through any types of problems. So it is way, way better to raise that age a little bit, not give full control too early. A question that we got recently was, by setting up these separate share trusts, am I creating a mess for my children? Absolutely not. I mean, if anything, what you're doing is you're providing flexibility for your children. For most people that we work with, their children are already in their 40s and 50s, and most of them are very responsible. So, with that said, if the children are adults and they are completely capable of being in full control, most of our clients are setting an age in the document for the beneficiaries to be in full control that is actually less than their age is currently, which means if mom and dad say you're in full control at 45 and the person is over 46, on the day of their death, they are in full control. So what that means is you are giving your children the gift of flexibility, the gift of choice, allowing them to decide at the time of mom and dad's death, do I want the money to be protected in the trust for my benefit, or do I want the money to go outright? Now, if we keep it protected, transfers on death are not subject to a look-back period, which means the assets would be protected the day after mom or dad died from car accidents, nursing homes, divorces, all of that would be automatically protected. So there is a huge value in keeping it protected. But in the situation where the child's in full control, they could get their money outright. When I meet with children after the parents die, I always say to them, assuming that they have the right to fire and they're in full control, if you want your money outright, you'll have it outright by tomorrow at noon. But let me explain to you the gift that your parents gave you of you being the only one who can touch it, you being the only one who can get it, you being the only one who can access it, but nobody else can, right? And I know a lot of people say to me, well, Jeff, if a person gets an inheritance and they keep it separate and segregated and it never touches the marital property, then it's protected. Sure. But I can tell you, I've been doing this for over 20 years, and I can count on one hand the times that somebody actually kept the money segregated. Why? Because they're happily married. They don't think anything will ever go wrong. Nobody ever walks down the aisle and says, this is going to be the best 4 years and 27 days of my life, right? So they're not expecting anything to go wrong. And because they're not expecting anything to go wrong, what do they typically do? They take the inheritance, they pay off the mortgage, they pay off the marital debt, and once that happens, it is now marital property. And if there is a divorce and it does get split, let's just call it 50-50, then that means that the child just lost the money that was given to them by their parents. And of course, every parent says to me, my child will keep it separate. They'll keep it segregated. They'll never allow it to touch marital. That's just not true. Kids are not thinking that way. They don't think anything would ever go wrong. So by setting up these separate share trusts, you're giving them the gift of choice, of flexibility. Evaluate the situation at the time of my death. I can tell you that it is very, 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 very rare. In fact, it just happened recently for the first time where a child actually wanted the money out of the separate share trust and didn't want them to stay protected. So you are not creating a mess. You are not creating a problem. Well, Jeff, how does the child get asset protection when the money goes into the trust? Well, let's go back to my daughter and my sister again. My daughter is going to be the co-trustee of her money with my sister at age 25. That allows my daughter to learn how to be a trustee, learn how to manage money, learn how to kind of make decisions like that. But she doesn't have full control until she's 45. But let's say she does turn 45. When she's 45, and let's say that she wants to use money, she wants the money out of the trust, she wants it. Generally, once she's in full control, what will happen is the co-trustee, my sister in this case, will say to her, look, I'm going to give you authorization to take your money when you want it. I have no say over the money. I have no control. I have no ability to get it. So it makes no difference to me. I'm just trying to help you. I'm trying to protect you from outside forces. So, Deanna, if you want your money, you could have it. And a lot of financial institutions allow the co-trustee to sign an authorization that says that Deanna can take her money whenever she wants. But we do need that co-trustee to sort of sign off so that we're getting that asset protection. Because remember what debtor-creditor law says. If I have direct access to the money, so too does the creditor. So we're using the co-trustee in a way that allows us to show that there is another person that's ultimately able to say no, but they're not going to. They have no reason to. They don't benefit from it. And once Deanna's 45, she can fire her Aunt Dina and appoint someone else. So once she can appoint someone else, she's in control, right? She can make sure she appoints somebody who will do what she wants, but it's not a hassle. It's not a mess. And in almost all cases, if done properly, it's the exact same tax consequences because the income will be K1 to the individual every year, and therefore the individual pays at the individual tax rates. Gee, Jeff, that means that the kid has to file a tax return every year. Yeah, a couple $100 for a tax return allows them to have 100% asset protection, to be the only one who can get the money, the only one who can access it. It is not a mess. It is not a hassle. It is a small cost each year to get full-blown asset protection, and almost always with the same tax consequences, which means there's really no downside other than paying a few $100s for a trust return. That's pretty much the downside. And because they're protected immediately after death and not subject to a look back, we already have it protected from long-term care costs, from car accidents, from divorces. It is a no-brainer, and it is not a big deal for the child at all. Similarly, one of the things that we do, which is a pretty advanced technique for spouses, is we are generally naming for retirement accounts the spousal-only retirement trust for the benefit of the spouse. After the Secure Act basically says that, the spouse can inherit the retirement account, stretch it out over life expectancy, blah, blah, blah. Well, what we can do with a spousal-only retirement trust is essentially the exact same thing, allowing the distribution to come out over the life expectancy and get asset protection on the remainder of it. Now, the downside after the Secure Act is that every year when those RMDs are coming out over the life expectancy, it has to come out of the trust. Well, that means when it comes out of the trust, we're losing the asset protection on that piece. So if the spouse lives to life expectancy, all of the money can be out of the trust. We can't stop it. We can't do anything about it. That is the way that the Secure Act was written. I don't understand it. It doesn't make any sense. But generally speaking, spouses want the money to go into the trust, again for flexibility purposes, so that in case the spouse is in a nursing home at the time of the other spouse's death, maybe they were in a car accident together, that would allow the spouse to only lose the required minimum distributions that are being paid out over life expectancy every year and not lose the nest egg. And if they pass away, then there would be money then to pass on to the family because they only lost the RMDs each year. So that's a great potential benefit to a spouse. What it also does is it ensures that the money doesn't then get taken and given to a new spouse or given to a new relationship. It stays in the family. But with retirement accounts, if they live to life expectancy, then unfortunately a lot of the money, if not all of the money, will be taken out of the trust. But that's only with retirement accounts. We can protect the other assets if it was owned individually in the decedent's name at the time of their death for the spouse, and there's no force out of any distributions for other than the retirement accounts. What we're always recommending is we name the spouse outright as the contingent beneficiary. So first it's going to be the spousal-only retirement trust, then it's going to be the spouse outright. The reason we're doing that is because if Secure Act 3.0 ever comes out, we have flexibility. I'm not going to be concerned with, okay, 3.0 came out, it's going to cause negative tax consequences, and I couldn't change the document, and now the spouse is going to get hammered. Because we have the spouse outright, the spouse can disclaim as the trustee of the trust and have it passed to whoever the contingent beneficiary is. Now, in our case, we're going to make the spouse outright as the contingent beneficiary, which would allow the trustee, a fiduciary, sitting in a higher capacity, owing a higher duty to the trust, to disclaim, not have it go into the trust, and have it go to the contingent beneficiary, who happens to be the spouse outright. Again, this goes back to the previous conversation of flexibility. We want to give flexibility to the spouse and to the children to make a decision at the time of death based upon the circumstances. And because we will have the spouse outright as the contingent, or after the separate share trust, we will have the child outright, we do have flexibility to disclaim out of the trust if that would cause any negative problems from a tax standpoint that we weren't expecting because of 3.0 or 4.0 or whatever new law they come up with. Flexibility is the key to estate planning. We don't ever want to be in a situation where if something changes or something happens that we're not expecting, we don't have an out. We definitely want to have an out. And that is why we use the spousal-only retirement trust for the retirement assets, and then the spouse outright is the contingent, and why we also do separate share trusts for the children, and then outright after the separate share trust for the child. We can also do special needs planning in trusts. We can name in the trust that the beneficiary is the supplemental needs trust or the special needs trust for the benefit of child, Jeff. That way the money is used for the child with the disability, but it is protected. Interesting fact, the Secure Act really was horrible when it comes to spouses and children because it forces the spousal required minimum distributions out over life expectancy. And for children, they have to take it all in a 10-year period with the Secure Act. But with an individual with disabilities, they can stretch it out over life expectancy. So there is some planning techniques and opportunities available there with the Secure Act using retirement accounts into a special needs trust, which before the Secure Act was unheard of. But what it allows us to do is to use what is called an accumulation trust and allows everything to accumulate in the trust and stay in the trust protected. Whereas with the spouse and the children, the Secure Act is requiring what is called a conduit trust, which forces the distributions out, which means we do not get asset protection. So that was a lot of fun. And if it was too much, I apologize, but we're getting these questions over and over again. And I decided that it was time to just get a deep dive into complex trust questions. I enjoyed it. I hope you did as well. Thank you so much for joining us on the Red Wagon Estate Planning and Elder Law Show, where we discuss all things estate planning and elder law, and well, hey, anything else we want to talk about. This, again, was a deep dive into trusts, into the weeds. Man, I had a lot of fun on this episode. We talked all about trusts in detail. We talked about what happens after death from an administration standpoint. Are the separate share trusts causing issues for my children? Why are we using the sort? Why do we have the sort outright as the contingent? We certainly went into a deep dive today, and I hope you enjoyed it. I'm Jeff Palomo, and until next time, we'll see you real soon.